Hello and a very warm welcome to latest case analysis series by Law Seeker. This is Monica Rahar, and for today's discussion, we have taken up a Supreme Court decision which is dated October 9, 2020. The name of the case is Branch Manager Bajaj Alliance Life Insurance Company Limited and others versus Dalbir Kaur. It is a three-judge bench decision of the Honorable Supreme Court, and the bench consisted of Honorable Justice Dr. D.Y. Chandrachud, Justice Indu Malhotra, and Justice Indira Banerjee. Now let's proceed and understand the issue of law. So the court was to decide whether insurance claim can be repudiated on non-disclosure of information which is sought in the proposal form by the proposer. So if I were to explain the issue of law simply, it meant that the court was to decide whether the insurance company can deny an insurance claim on the ground that the person who wanted to avail himself of the insurance benefits, or to say the proposer, he did not furnish certain information which was sought out of him in his application form, or also known as the proposal form. Now, having understood the issue of law, let's proceed with the brief facts of the matter. So, in the year 2014, in August, Kulwant Singh, who is essentially the son of the respondent, who is Dalbir Kaur, so her son Kulwant Singh, he submitted a proposal for insurance policy to the appellants, and respondent, that is Dalbir Kaur, she was mentioned as a nominee. The proposal form, it had certain questions about the proposer's health, his medical history, and it required disclosure of ailment, any hospitalization record or treatment which the, if any, if at all any, which was undergone by Kulwant Singh. Now, Kulwant Singh, he answered all these questions in negative. That is to say, he stated that there was no medical history or any hospitalization record, and neither was he going through any ailment. There were also specific queries regarding respiratory ailment, which were again answered in negative by the proposer. Now, in the same month, in August 2014, insurance was given, and the proposer's life, it was insured for a sum of rupees 8.50 lakhs, and it was payable on maturity with death benefit of rupees 70 lakhs. In September 2014, that is the very next month, Kulwant Singh died and the claim was lodged on the insurance. Now, usually the insurance companies, they conduct independent investigations in order to ascertain the validity of the amount claimed, and also to rule out any possibility of fraud or anything of the sort. So, during the investigation which was carried out by the insurance company, in this case, in order to ascertain the validity of the claim, during this investigation, hospital treatment records and medical certificates of the deceased came to the forefront and they were obtained. And it was found that he was suffering from hepatitis C. The investigation report, which was submitted, it indicated that proximate to the date of death of the deceased, he had been suffering from stomach ailment and vomiting of blood, which eventually led him to avail himself of treatment, and he was also hospitalized. So, keeping in mind these facts, or the disclosure of these facts which were not disclosed by the proposer in his proposal form, the claim of the proposer is it was repudiated by the insurance company on account of non-disclosure of the material facts. Now, aggrieved by such a repudiation or denial, the mother of the proposer, the deceased proposer, who is also the respondent, she instituted a consumer complaint before the District Consumer Dispute Redressal Forum, and the complaint was allowed, and the insurance company was directed to pay full amount along with interest. Now, aggrieved by this decision of the District Consumer Forum, the insurance company preferred an appeal before the State Consumer Forum. The State Consumer Dispute Redressal Commission, however, rejected this appeal, and therefore a revision petition was preferred before the National Consumer Dispute Redressal Commission, and the National Commission also dismissed the revision petition. And the reason for dismissing the petition were the following: that a disease has to be distinguished from a mere illness, and death caused due and the death of the disease, it was caused due to natural causes. And also the National Commission noted that no reasonable nexus could be found between the cause of death and the non-disclosure of the disease. And therefore the National Commission imposed cost of rupees 2 lakhs on the appellant. Rupees 1 lakh was directed to be paid to the complainant, while the remaining half, that is rupees 1 lakh, it was directed to be paid to the Consumer Legal Aid account of District Forum. Now, aggrieved by this decision, the insurance company or the appellant finally reached the Supreme Court. Now, let's proceed and understand the case of the appellant before the apex court. So, the appellant at the very outset contended that the judgment of the National Commission, it was contrary to the law which was laid down by the Supreme Court in three cases. The first being Life Insurance Corporation of India versus Asha Goel. Second being PC Chaco versus Chairman Life Insurance Corporation of India. And third being the case of Satwant Kaur Sandhu versus New India Assurance Company Limited. So, in all these three cases, the Supreme Court laid down a proposition of law governing this issue of law, and hence it was the claim of the appellant that the judgment of the National Commission was contrary to such a law which was laid down by the apex court. Secondly, it was contended that the insurance policy is governed by the principles of utmost good faith, and the investigation reports revealed that proximate to the date of death of the deceased, he was hospitalized with a complaint of having vomited blood, and a non disclosure of this material fact would justify the repudiation of the claim by the appellants. The proposer was duty bound to make a full disclosure, and also it was contended that suppression of material facts entitles the appellants to repudiate the policy of insurance in terms of Section 45 of the Insurance Act 1938. Now let's have a look at Section 45 of the Insurance Act. So this section, it stipulates that an insurer is restricted from calling into question a life insurance policy after the expiry of 2 years from the date on which it was effected, on the ground that a false or inaccurate statement has been made in the proposal, or such a statement has been made in the report of a medical officer or of a referee or a friend of the insured, or in any other document leading to the issue of policy. So essentially this section, it provided that an insurance company or an insurer is restricted from calling into question or questioning the validity of a life insurance policy once the period of 2 years is expired, and such a questioning, it should not be done on the grounds of these three, that is the statement it is false and inaccurate, and the statement whether it is made in the proposal or be it made in the report of a medical officer or in any other document which is leading to the issue of policy. So such a question, should be raised, such an alarm, it should be raised within the period of 2 years and not beyond that. Now, having understood it, let's proceed and get back to what we were discussing. So, it was the claim of the appellant that suppression of material facts, it entitles the appellant to repudiate the policy under Section 45. However, in the present case, the period of 2 years, it has not been completed. So it was stated that on expiry of 2 years, the burden of proof, it shifts to the insurer, who has to establish that false or inaccurate statement was a material matter or related to material facts. However, the claim in question it was repudiated within 2 years from the commencement of the policy. Now let's proceed and understand the reasoning and decision of the court. So the court stated that a contract of insurance is one of utmost good faith, and a proposer who seeks to obtain a policy of life insurance is duty bound to disclose all material facts which have a bearing upon the issue as to whether the insurer would consider it appropriate to assume the risk which is proposed. Secondly, the court stated that the proposer failed to disclose the vomiting of blood, the fact of vomiting of blood, which was very proximate to the date on which the deceased in fact died, and also the hospitalization record which had been occasioned as a consequence of vomiting of blood. The court also stated that investigation by the insurer indicated that the assured, which is the deceased Kulwant Singh, he was suffering from a pre-existing ailment consequent upon alcohol abuse, and that the facts which were in proposer's knowledge were not disclosed in the proposal form, and the medical report records which were obtained during investigation, they clearly indicated that the deceased was suffering from a serious pre-existing medical condition which was not disclosed by the insurer. Therefore, the judgment of the NCDRC does not lay down the correct principle of law and therefore was set aside by the court. The appellant, the court stated, has informed the court that during the pendency of the proceedings, the entire claim was paid over to the respondent, save and except for the amount of cost. So the court noted that the insurance company informed the court that it is already paid the entire claim amount, save and except for the amount of cost. So the court noted this fact. However, the court also noted the fact that the age of the respondent was 70 years and she was dependent on her son who is now dead. Therefore, the court exercised its jurisdiction under Article 142 of the Indian Constitution, and the court directed that no recoveries of the amount which is already been paid by the insurance company shall be made from the respondent. So the court directed the insurance company not to recover the amount which is already been paid to the respondent. However, while doing so, the court expressly held that the impugned judgment of the National Consumer Dispute Redressal Commission it did not lay down the correct position of law and hence it was set aside by the court. So, what we need to extract from this entire case analysis is that the issue of law it was answered in the affirmative by the court, and the court stated that the insurance company can in fact repudiate or deny a claim of an insurance if the proposal form it does not disclose properly the information which is sought out of the proposal. So at the end of the note, you may find a list of abbreviations which we have used in note. You may refer to it in order to get a clearer hold of the note. Here's the list, and that's all we have for this case analysis. Thank you for being with us.